In this module, we're going to be examining the role of criminal law in the criminal justice system. In particular, we're going to begin with a broad overview, a context for criminal laws. So we're going to talk a bit about some of the guiding principles of criminal laws, which can be subsumed under the moniker of the rule of law. And we'll also talk about different types of laws, in particular public versus private law. And then the context of this is that criminal law is a public law as opposed to a private law. We'll then get into some specifics of criminal law. So we'll begin by defining what a criminal law is and then define what a crime is within the Canadian context and the common law context generally. We'll then talk about the two primary sources of criminal law in Canada. The first is the tradition of common law, the British tradition of common law. And secondly, we'll look at how criminal law derives from both statute law, which is legislation, and case law, which is decisions made by the courts. We're next going to delineate between summary and indictable offenses, and this is a broad delineation based on how serious an offense is. And finally, we're going to talk about the processes that are necessary to amend the criminal code and use a couple of case studies to illustrate that. I want to begin by discussing some of the basic principles of laws and criminal law in particular. And this is basically known as the rule of law. All legal systems in Canada are governed by the principle of the rule of law, which can be traced back to the English Magna Carta of 1215, which we discussed in a previous lecture. So a key component of the criminal justice system is the rule of law, the idea that no one is above the law, that everyone in society is bound by the same laws and entitled to protection under the laws, and that the law should be observed and enforced equally. In essence, the rule of law means that all citizens are subject to the law and entitled to its protections. And while this is an admirable principle, it's one that's often very difficult to ensure. So some of the key aspects of the principles of law and the rule of law and criminal law in particular is, first of all, the scope of law, and that means that the law applies to everyone. Nobody is above the law. And that basically means that whether you're rich or poor or whatever race or ethnicity you're from, the law must treat you equally. The second is what's known as the character of law, and that is that the laws should be clear and they must be public. And this is essential because the last thing that any kind of democratic free society needs are secret laws. So the most important principle is that they must be public. People must be aware of what the laws are. As you probably may have heard, ignorance of the law is no excuse. Sometimes laws are not always so clear, and in fact the criminal code can be very complicated and difficult to read, a lot of legalese. But at the very least, it is a public document, and in this age of the internet you can find the criminal codes on various websites. So certainly in this day and age the laws are definitely public in this country. Not so clear all the time, but definitely public. The final set of characteristics is what we call the institution of law, and this is how laws are applied. First of all, there needs to be an independent judiciary that applies the law and that adjudicates the law. Political appointees, judiciary that are under the thumb of governments that have to answer to governments does not promote fair, just laws, because they become subject to political interference. So you see in totalitarian governments and communist countries, the judiciary is not independent from the government, and the judiciary often makes decisions, court decisions, based on politics, and laws are interpreted not in an unbiased way but in a very unjust way. So in Canada, an essential aspect of the legal system is that the judiciary is independent from the government. They can make decisions without having to fear any kind of government repercussions. An extension of the idea that laws are public is that the laws must be written. They must be codified somehow in statutes, and again, this is very similar to the idea that laws are public, in the sense that they should be written and they should be formalized. And finally, there's the aspect of a fair and public hearing. Within the context of criminal law, every citizen must be guaranteed not only a fair trial, but that trial is public and it's open to the public. And that's something a lot of people don't realize, is most criminal trials, if not all criminal trials, are actually open to the public. The difficulty is, if you want to attend a trial, is getting a seat in a criminal trial in the public gallery, which is often difficult to do. But most criminal trials, the vast majority of criminal trials, are public, which means that they can be reported on by the media. The only basic restriction is that in Canada, you cannot videotape a ongoing criminal trial, and you can't take photos either, unlike some jurisdictions in the United States where you can bring a camera into a courtroom. You can't do that in Canada. There's no types of photography or video camera. But notwithstanding that, criminal trials in Canada are public, which means they're open to public, and in general, they can be reported on by the media. Another context within which we're going to discuss criminal law is whether criminal law falls into public or private law. Criminal law is definitely a public law. And so in general, in most common law societies, there's two types of laws. There's public laws and there's private law. So public law deals with those matters that affect society as a whole and its interactions with government. So there's basically four types of public laws. There's criminal law, constitutional law, administrative law, and taxation law. And we'll obviously just deal with criminal law as a public law. Now, when you compare criminal law to, say, civil law, criminal law is basically between the state and a private citizen, while civil law or private law is between two private entities, whether those two private entities are citizens or companies or governments, or between a citizen and a government, such as a citizen suing a government. But when a crime that is a criminal law violation is committed within the context of public law, the government assumes the responsibility for prosecuting the alleged offender. So that's a relationship, primary relationship within the context of public law, is that it's the government that prosecutes the alleged offender. So it's between the offender and the government. So the criminal courts, on behalf of the victim and the community, undertake the task of determining the guilt or innocence of the offender. The criminal court then imposes a sanction, which may involve supervision of the offender in the community, or a period of confinement in a correctional facility, and there may also be a financial penalty attached to the judgment of the court. In contrast, civil law is essentially concerned with disputes between two individuals or two or more individuals. So civil law includes all statute law other than criminal law, such as divorce and human rights laws. So in civil suits, the person who feels they're being wronged by the alleged behavior of another brings a civil suit into a civil court. And so they sue somebody, and that's what's called a civil suit. So the wronged party seeks damages, which usually involves the payment of monetary compensation by the wrongdoer if the court finds that the wrongdoer is liable. And so the most types of civil suits include divorce, disputes over inheritances, breach of contract. But one thing that should be said, that civil law is increasingly being used to combat crime. In other words, the state is starting to rely on civil laws to combat crime. In particular, what they'll do is they'll actually sue a defendant in the civil courts, or use the civil courts to seize their assets. And there's a lot of controversy about this because a lot of people feel that they're abusing the system. Now, one of the most significant differences between criminal law and civil law relates to the standard of proof required to convict a person of wrongdoing. In a criminal trial, the prosecutor has to prove the defendant is guilty beyond a reasonable doubt. Okay, beyond a reasonable doubt. So that places a particularly strong onus on the prosecutor. Now, in a civil trial, liability is determined by the standard of, quote, the balance of probabilities, end quote. or otherwise known as reasonable probability or reasonable belief. And that is a much lower standard of proof. So basically arguing is in a criminal trial, the prosecutor has to prove beyond a reasonable doubt that someone's guilty, so the judge or the jury cannot have any kind of indecision or a suspicion of innocence. While in a civil trial, it's basically a reasonable belief. So it's based on what a reasonable person would believe to be the facts of the case. In other words, again, I suspect that this person is guilty, or I suspect that this person is a better parent, so they should be awarded custody of the child, or I suspect that this individual libeled another individual and therefore is justified in their civil suit. So the standard of proof in a civil case is much lower in a criminal case, and that's a fundamental difference between public law and private law. And that's one of the reasons why governments are using civil laws sometimes to sue criminals, because the burden of proof on the government as the litigant in the case is much lower than in a criminal case. But in general, the most important thing to remember is that a criminal law is a public law in the sense that it's between private citizens and the state, and secondly, that the standard of proof in a criminal law is very onerous. Now that we've provided some context for criminal law, we can go ahead and now define what actually is meant by criminal law. And one definition is that a criminal law is the body of law that deals with conduct considered so harmful to society as a whole that is prohibited by statute, prosecuted, and punished by the government. And this is a source, if you see the website in this particular slide, that's actually a really good website for legal information. It's a Canadian website and has all sorts of information on criminal law and public law and civil law. So for more information on law, if you're interested in laws and perhaps aspire to be a lawyer, you may want to visit that website. And it's also a useful website to reference for assignments for this course, especially assignments that are concerned with law and criminal law in particular. So flowing from the aforementioned definition of criminal law, basically what criminal law is supposed to do, and what the criminal code does in Canada, is it provides the guidelines for how order is maintained in society. It's a blueprint for social control. In particular, it defines the parameters of acceptable and unacceptable behavior, and specifically, it defines what is unacceptable behavior. And in that context, it basically criminalizes what the government or society as large deems to be unacceptable or criminal behavior. So criminal laws criminalize certain behaviors such as break and enter or sexual assault, and it also criminalizes certain goods and services such as drugs and prostitution or bookmaking, for example. Criminal laws also outline the punishment for prohibited behavior, and it also outlines the powers and the limitations of the powers of the state when enforcing laws. And in particular, if you look at the Criminal Code and Part 6 of the Criminal Code, this part outlines rules regarding electronic surveillance by police. So this is an example of a part of a criminal code that specifies what police must do in order to electronically survey a potential offender or an accused or a suspect. And so it outlines the steps they have to take to get a warrant to conduct electronic surveillance, and this part also outlines the limitations on police powers with respect to conducting electronic surveillance. And this part of the criminal code is particularly salient. The reason that details on electronic surveillance are spelled out so articulately and then detailed within the criminal code is that electronic surveillance is a very intrusive type of enforcement. The government listening in on people's phone calls or videotaping them is obviously very intrusive and a real invasion of one's privacy. So therefore the courts and the government has deemed that there needs to be very strong rules in place to outline what the police can do in order to conduct electronic surveillance, but also the limitations on police to limit their powers so that they don't abuse their powers, abuse this type of very intrusive form of enforcement. So criminal laws again provide the broad guideline on how orders to maintain in society by government by outlining the parameters of certain behavior, by criminalizing certain behavior, but also outlining and placing limits on the power of the state in carrying out these functions. Another important aspect of criminal law is defining what exactly is a crime. A crime can generally be defined as a deliberate, reckless, or negligent act that injures another person or causes damage to property. Now, for an act to be considered a crime, or for behavior to be considered a crime, there has to be two basic features. And these are defined in the Latin terms. So there's what's called mens rea, and that basically means that the offender has to have a guilty mind. There has to be criminal intent involved. That's why in many cases, if someone, say, is killed by accident, then they're not considered criminally liable. So it's important that the individual demonstrates some mens rea, which means that they have a guilty mind or a criminal intent. And that can be either general or specific intent. In other words, if they broke into a home and accidentally killed somebody, they may not have set out to kill somebody, but in the process of committing a crime, they accidentally killed somebody, then that is considered part of the criminal intent, and so they would be guilty of, in this case, probably second-degree murder. The second principle is what's called actus reus, and that is that a criminal act has to actually take place. In other words, it can't just be a fantasy. You can't arrest somebody because they fantasize about committing a criminal act. But there's one important exception to this, and that's what's called criminal negligence. And this is related to both the mens rea and actus reus. So, for example, someone may not have set out to kill somebody, but if they get behind the wheel of a car while they're drunk and they kill somebody, then that is considered criminal negligence. Criminal negligence is basically that you've acted so irresponsibly, you've acted with such negligence to cause harm or death to somebody that you are criminal. So you never set out to kill somebody. You never set out with a criminal intent when you got into the car to drink and drive. At least you never set out to kill anybody. But you were so negligent that your behavior is deemed to be criminal. And so that's obviously the extreme of negligent behavior, when that behavior actually enters the realm of criminal behavior. So this is very complicated. It seems fairly straightforward, but it's very complicated once you get into a court what actually constitutes a guilty mind or criminal intent. But if you're a prosecutor or a judge or a jury and you're determining on the guilt of an individual, certainly these two criteria are fundamental to determining whether or not a person is guilty of a criminal offense. Another couple broad ways we can classify criminal laws is whether they're substantive or procedural laws. So a substantive law is a law that spells out the specific behavior which is required or which is prohibited. So in the context of the criminal code, a substantive law are those sections or those parts of the criminal code that basically prohibit certain behaviors, whether it's sexual assault or theft or robbery, whatever. And so basically much of the Criminal Code of Canada is made up of substantive laws, sections that identify what types of behaviors are prohibited and the penalties for these behaviors. The second aspect of criminal law is what we call procedural law. And this basically describes how law enforcement agents must act in dealing with an offense. And while substantive law is codified in the Criminal Code of Canada, how law enforcement agents or criminal justice officials are to act in dealing with offense is very much guided by the Charter of Rights and Freedoms. So it's the Charter of Rights and Freedoms that lays out the limitations and restrictions on how police can act with respect to a substantive criminal offense or with respect to their enforcement of an offense. So procedural law dictates, for example, when a police officer can enter a building, when they can search a building, when they can undertake electronic surveillance, for example. So the criminal code contains both substantive law and procedural law. And as we talked about in the previous slides, the Part 6 of the Criminal Code that specifies the limitations and restrictions on electronic surveillance is a good example of a procedural law. I'll also use the example of sexual assault as one that shows the differences between substantive law and procedural law. So in 1983, there was amendments made to the Criminal Code regarding sexual assault, and these amendments impacted on both substantive law and procedural law. So with respect to substantive law, the legislative changes basically took the offense of rape and replaced it with 3 degrees of sexual assault. So the Criminal Code no longer defines sexual assault as rape. It defines it as sexual assault and breaks it into 3 different categories based on severity of the sexual assault. So that's how the legislative amendments changed the substantive aspect of this offense. Now, it also changed certain procedural aspects of the law. And in particular, what it changed was that the defendant, the person who committed the sexual assault, cannot inquire about a victim's sexual past in the court. This is what's otherwise known as the rape shield law. So it's shielding the victim from being victimized again on the stand. But the important point here is how certain legislative amendments, or how the criminal code in general, has both substantive law aspects and procedural law aspects. And so while we think of a criminal code mostly made up of sections that detail behavior and acts that are prohibited, there's actually a number of sections in the criminal code that again outline the certain procedures that must be undertaken by law enforcement officials or others involved in the criminal justice process. And the sexual assault, or the rape shield law, the amendments in 1983, are also a good example of how the criminal code is amended and how both substantive and procedural laws will be changed from time to time. And procedural law, as mentioned in a previous slide, is most impacted by Supreme Court decisions or Superior Court decisions regarding the processes or procedures and how these laws are enforced. And so I would refer you to the website that's provided at the bottom of the slide for a really good case study on how the criminal code gets amended, how criminal laws and procedures are subject to constitutional challenges, and how success in these challenges can lead to change in laws in both substantive and procedural laws. We're now going to talk about sources of criminal law in Canada, and I'm using the term source in 2 different ways. First of all, one particular source that we have to look at is the historical source, and that is that we derived our common law system from Britain. So one of the major sources or major influences on our criminal law and our criminal legal system is Great Britain. And the another way we're looking at it is where we actually get criminal laws from in Canada or from any country that follows the common law system. And in this context, there's 2 sources of criminal laws. The first is what we call statute law, and that's basically legislation. And the second is what we call case law, and these are decisions made by the courts. And we're going to talk about these different sources in a little more detail. So as we have discussed in previous modules, the Canadian criminal justice system, and criminal law specifically, was inherited from the Britain, in particular what's known as British common law. Um, and as we talked about in previous lectures, really under Henry II, King Henry II, who had an very influential role in modernizing the criminal law system, or laying the foundation for what we know today as the common law system. And there's really three aspects to the common law system. The first of all is that the government passes laws, so they write the laws and they codify these laws in statutes. The second is that judges are appointed to administer the law, so they hear cases and they share decisions, and this is what's known as case law or precedent law. So in the first, we're talking about statute law, so governments write laws and codified laws into legislation. The second is where judges interpret laws, and this is what's known as case law or precedent. And the third aspect of common law that originated in Henry II was the fact that private wrongs, so these are wrongs between two individuals, two private individuals, are now crimes against the state. And again, this was an important innovation brought in by Henry II that obviously is still around today. So before Henry II, as we've discussed, if there was a particular grievous act committed between two peoples, like a rape or murder, traditionally that was to be dealt with by those two individuals, or perhaps at a communal level. And what Henry II did was basically say that the type of crimes or behaviors that not only injure an individual, like rape, they injure the whole society, and therefore these particular behaviors have to be treated as crimes, and they have to be treated not only as crimes against a victim, but crimes against society as a whole, and therefore they need to be prosecuted, they need to be investigated and prosecuted and adjudicated by the government and not by private citizens. So three aspects of British common law that are still in place in common law countries like the UK, United States, and Canada is that the government passes laws, which are known as statute laws. Judges are appointed to administer and interpret laws and then share case decisions with one another, which we'll talk about in a bit. And also that certain behaviors that are particularly injurious to a party, like physical harm, is no longer between those two parties, but it's now falls under the jurisdiction of the state, because the grievous harm is considered so damaging to the individual and society that it's considered damaging to society as a whole, and therefore it's the government who's responsible for prosecuting that. As we have alluded to in previous slides, in any common law country, criminal law and civil law for that matter derives from two sources within that country. The first is what's known as statute law, which is legislation like the Criminal Code of Canada, and the second is case law, and this basically means that courts administer and interpret law, and they share decisions with one another, which is known as case law. In other words, courts follow the decisions made by other courts, and as importantly, lower courts must follow decisions set by higher courts. And in Canada, the highest court is the Supreme Court, and all courts in Canada must follow the decisions, the precedents set by the Supreme Court of Canada. So getting into statute law in a little more detail within the Canadian context, as we've discussed earlier, the Canadian Constitution divides powers between the federal and provincial governments with respect to the criminal justice system. And the Constitution states that only the federal government can create criminal law. And specifically, it's Parliament that creates criminal law, or Parliament that passes criminal law. So the primary responsibility for creating criminal law lies with the federal government or federal parliament, and it's up to the provinces to enforce these criminal laws. So within the power of each attorney general for each province is the responsibility to enforce or administer the Criminal Code of Canada. Now, some provinces have tried to implement quasi-criminal laws, but provinces can never actually write a criminal law, as they can never actually amend or provide really any substantive input into the criminal code. Although again, the federal government will listen to the provinces with respect to amending the criminal code, but in no way, shape, or form are the provinces actually involved in writing or rewriting any aspects of the criminal codes. But they will, within their boundaries, develop some laws, in particular civil laws or administrative laws, that are aimed at criminal offenders. And these are controversial, and some have not survived Supreme Court challenges, constitutional challenges, and we'll talk about this in a bit later in this module. So within Canada, obviously the principal statute law with respect to crimes and criminal offenses in Canada is the Criminal Code of Canada. This is the main piece of criminal legislation in this country. It is the prime example of what constitutes a statute law or a statute criminal law. And as we talked about before, other statute criminal laws include the Controlled Drugs and Substances Act and the Youth Criminal Justice Act. Within Canada, all criminal laws, as mentioned, are passed by Parliament, and they're basically written by lawyers within the policy section of the Department of Justice in Ottawa. And sometimes the Department of Justice will actually contract out the writing of criminal laws to lawyers and legal professionals and legal professors, law professors, to write these laws. So all statute law in Canada is subject to the Charter of Rights and Freedoms. In other words, it's up to the courts to decide if the law is legal, if it adheres to the Charter. When courts strike down a law or make a decision that argues for the amendment of a law, it's basically back to the government to amend that law or reword it so that it actually conforms to the court decision, in particular the Supreme Court decision. So again, an example of statute law that was struck down was abortion. Abortion actually used to be a criminal offense, and many years ago the Supreme Court determined that women have the right to an abortion, and so it is no longer in the criminal code. But again, in summary, the important thing to remember is that statute law is created by the government, created by federal parliament, and the Criminal Code of Canada is the main source of statute law with respect to criminal offenses in this country. So as I mentioned, while it's up to the government to create and enforce laws, it's up to the courts to administer and interpret laws based primarily on the Charter of Rights and Freedoms. And this is what's basically known as case law. When a court decision is made, and if it's a particularly important court decision, then that's referred to as case law or precedence or jurisprudence. And that basically means that a particular court decision has set a precedent that other courts are to follow. The stack of books you see in the graphic there is symbolic, but it also shows that when you're a lawyer or if you're a judge, that you're constantly referring to case law to argue your case or make a decision. And so if you go to a law office or a judge's chambers, you'll see row upon row of books that basically contain case law. In other words, decisions made by courts, by judges, that are influential or that set a precedent. So if in the common law system courts are to follow the decision of other courts, then case law is the most important foundation in the respect of these decisions that courts are to follow. And as we discussed, the Supreme Court of Canada is the highest ranking court in this country. So any decision made by the Supreme Canada, any precedent or jurisprudence set by the Supreme Court of Canada must be followed by all the other courts in the land. So criminal law is created, is interpreted, is refined and modified through decisions made by the court, by different courts. And again, the most significant changes or the most significant decisions made by the courts are decisions that are often followed by other courts and can actually lead to amending of the criminal code. And there's been numerous incidences, especially since the charter was introduced in 1983, in which the criminal code has had to be amended because of court decisions. And there's a particular controversy swirling around Canada and the United States as well, and that is that judges are being criticized because they're considered to be too activist. And it's often those on the right that are most critical of judges, because those on the right, conservatives, tend to view judges as very liberal in their decisions. And so these liberal decisions tend to go against the kind of law and order principles of conservatives. So critics argue that these activist judges are making decisions that the legislature should be making, that the federal parliament should be making. In other words, many laws are being created through case law, through decisions of judges, and not through Parliament. And so I've included an article in your readings. It's from Maclean's magazine, and it basically outlines the tension that exists between the Harper government, the Conservative government, and many of the decisions made by judges that interpret laws that have been brought in by the Conservatives, and many of the decisions have gone against the Conservatives. In other words, they've ruled that these laws are unconstitutional, and it cites a couple examples in there. And so right now, you have the Conservatives bringing in Bill C-10, a very punitive piece of legislation that includes mandatory minimum sentences, and already the courts are deciding on cases that have been brought to the courts under these provisions, and in some cases they're arguing that these laws are unconstitutional. In particular, they're arguing that mandatory minimum sentences constitutes unjust and arbitrary punishment on particular offenders, because the laws don't take into consideration the circumstances of that offenders. So the important point is that, again, government creates laws, but it's up to the courts to interpret those laws, and in their case law, they will often help to modify and even completely replace sections of the criminal code. And again, this is adding to the controversy, because those on the right believe that the most important decisions about changes to the criminal code should be made by the legislature, by federal parliament, and not by the courts. But this is the reality of the common law system, is that to balance the power between the government and the courts, the independent judiciary, the judiciary will weigh in and make sure that the laws that governments are creating are just and do follow the principles of law. So simply within this common law system, there's bound to be this controversy, but it's probably the best system out there, because you have a balance of power between the federal government and the judiciary, and the judiciary basically acts as a source of a regulator with respect to government laws. And many people are applauding the judicial decisions being made about the conservative laws, because they feel that these laws are unjust, and the justices have ruled accordingly in some cases. So just to summarize the role of case law in creating criminal law in this country, because it's a little more complex than statute law. The aspects of case law is, first of all, that precedents set in previous cases are used as a basis for decisions by the courts in future cases. Case law means that equal rank courts follow each other's decisions if possible. So a lower court in Saskatchewan will follow the decision made by another lower court in Saskatchewan, or perhaps in BC or Alberta. Court decisions can be appealed to higher courts. The ruling of the highest court prevails. In other words, the Supreme Court decisions or provincial superior court decisions have to be followed by the lower court. And the Supreme Court of Canada has the final say on case law. And again, the important point as far as the creation of criminal law is concerned is that Supreme Court is very influential and very powerful, in the sense that it can tell the federal government whether or not a particular law, whether it's substantive law or procedural law, conforms to the Charter of Rights. And if it doesn't, the Supreme Court can actually strike down that law, so remove it from the criminal code, or force the government to modify the law. So that's the role that the courts, and in particular the Supreme Court, plays in creating and modifying statute criminal law in this country. So now that we've defined what criminal law is, what constitutes a crime, and the sources of criminal law in Canada, I'd like to turn to another way that we delineate crimes in this country. And in Canada, there's basically two categories of criminal offenses, and these categories are determined by the seriousness of the offense. So in Canada, we have what's called summary offenses, and we also have indictable offenses. So summary offenses are the less serious crimes, and indictable offenses are the more serious crimes. And in the United States, the terminology that's used, which you may hear in the Cops and Robbers TV programs, is misdemeanors and felonies. So the misdemeanors are the summary offenses and felonies are indictable offenses. But in this country we don't use that terminology. We use summary and indictable offenses, not misdemeanor and felony offenses. So what is a summary offense? Well, a summary offense in general is considered a minor offense, and typical examples of a minor offense is break and enter, or even possession of marijuana under the Controlled Drugs and Substances Act. The maximum penalty for a summary offense is $2,000 fine or 6 months in jail. And in some few cases of summary offenses, an offender can spend up to 18 months in jail. A summary offense is always heard by a provincial court judge, a lower court judge, and the case must be heard within 6 months. So that's 6 months after the individual's been charged. The case has to be heard by a provincial court. And anybody convicted of a summary offense will serve time or is allotted to serve time in a provincial facility, so not a federal facility. However, in the vast majority of cases involving summary offenses, the sentence is probation. And again, that is a reflection that the offense is rather mild. It's rather, well, I shouldn't say mild, but certainly it's minor. And given the philosophy of the Canadian criminal justice system, the idea is that you only incarcerate individuals convicted of serious or indictable offenses. So if a summary offense is one that is less serious, and obviously an indictable offense is one that's more serious. And basically indictable offenses are defined by the maximum penalty that can be applied to them. So all indictable offenses are ones where the maximum penalty is 2 or more years. So armed robbery, sexual assault, a murder, these are all considered indictable offenses. Now, if a summary offense case can only be heard in a lower provincial court by a judge, a more serious indictable offense is heard in the Superior Court of each province. So as we talked about before, criminal courts in the provinces are divided between the lower courts or provincial courts, which hear summary offenses, and the Superior Courts, which tend to hear more serious or indictable offenses. Now, another important differentiation is that a defendant who's been charged with a summary offense does not have the option to choose between a judge and a jury. They basically are assigned a judge, and that's it. There's generally no jurors in a common or in a summary offense trial. In an indictable offense, the defendant actually has the option to choose a judge-only trial or a trial involving a jury. And so this is what's called an election offense. The accused may opt for a jury. Another difference between a summary and indictable offense is that in indictable cases, many indictable cases, a preliminary hearing is held to determine whether or not there is sufficient evidence to proceed to trial. And so that is not the case in summary offenses. There's no preliminary trial. So the difference between a summary and indictable offense is not symbolic or hypothetical. It determines the procedures that are followed with respect to the court trial proceedings. So again, the important distinctions in a summary offense is that a defendant only has access to a judge, but in an indictable offense, they can choose a judge or a jury. In indictable offenses, there's a preliminary trial. In summary cases, there's not. So this delineation between summary and indictable is not simply hypothetical or to categorize certain crimes. There's implications for how a case proceeds through the court system based on whether it's a summary or indictable trial, a summary or indictable offense. So just one example of an indictable offense, the most serious of all indictable offenses is homicide. And unlike many indictable offenses, the offense of homicide is actually broken down into different categories based on the seriousness of the offense. So the most serious homicide is what's known as first-degree murder. And this is where an offender has planned the offense, there's premeditation, they've killed a police officer, or someone was killed during the course of another crime, such as an armed robbery. The penalty for first-degree murder is mandatory life imprisonment, which means that the defendant has no chance of parole for 25 years. The next category of homicide is what's called second-degree murder. And this is any other intentional killing outside of what's articulated in first-degree murder. So it wasn't planned. They didn't kill a peace officer. It didn't take place during another crime. And most homicides tend to fall in the second-degree murder category. There's mandatory life imprisonment under second-degree murder. However, the main difference is that the accused or the person convicted actually is eligible parole as early as 10 years. So the sentencing judge will generally determine when the convicted can apply for parole. The third category of homicide is what's known as manslaughter, and this is basically where someone dies in the context, say, of an assault or criminal negligence or the heat of passion. So there was never any kind of criminal intent to kill. It was accidental. It was in the context of, say, drinking and driving. And again, there's maximum life in prison, but there is parole eligibility that begins at around 10 years. Now, the final category of homicide is one that's quite unique, and it's actually called infanticide. And this involves cases where a newborn baby has been killed by their biological mother. And it's called infanticide because it's a specific type of psychological or psychiatric disorder in the sense that the biological mother is suffering from what's called postpartum depression, and this is a clinical disorder that could lead the mother to commit heinous acts against their newborn. And so you can see here that the maximum sentence is only 5 years. That's the maximum, not the minimum. Now, the reason you have such a low maximum sentence is because the mother is basically suffering from a psychiatric disorder. So like the plea of insanity, the argument here is that she was not capable of understanding her actions due to the psychiatric condition. So many mothers who are convicted of infanticide, in fact, are released on probation. So it's a very unique and obviously a very controversial provision, and one that's very unique in the criminal code because few provisions allow for such a lenient sentence due to psychiatric conditions. But again, it's very similar to a plea of insanity where the individual, the defendant who's convicted, will not receive a first-degree murder charge simply because they were deemed by the courts not to be able to understand their actions. So, but this homicide is basically an example of an indictable offense and how some indictable offenses are broken down into various levels, and these various levels have different penalties based on the severity of the offense. Now, in addition to summary and indictable offenses, the criminal code also has what's called hybrid offenses. And these are certain offenses that can be treated as either indictable or summary offense based on the option that the prosecutor wants to pursue. And again, it's really up to the discretion of the prosecutor to decide based on the context of the offense on whether they should proceed to prosecute the offense as an indictable or summary offense. And so here's another good example of the discretion that's given to criminal justice actors, in this case the prosecutor, to decide on how to proceed with the case. So it's really up to the prosecutor to decide based on the circumstances of the case whether it should be prosecuted as a summary or indictable offense. So one example of a hybrid offense is sexual assault. As we talked about earlier, the criminal code now has three different levels of sexual assault, similar to homicide, in the sense that these levels are categorized based on the severity of the actual assault. So the first level of assault is what's known as common sexual assault. This is the lowest level of assault, the least physically intrusive and damaging, and it generally can consist of someone touching someone else. It can even involve unwanted staring at someone, but it doesn't involve any kind of serious physical harm to the victim. And so this is considered a hybrid offense. This is where a prosecutor to determine and decide whether to prosecute the offense as either an indictable or summary offense. So in the case of a level 1 sexual assault, if it's prosecuted as a summary offense, the maximum sentence is 18 months, and if it's an indictable offense, the maximum sentence is 10 years. So you can see the difference between the penalties based on whether it's a summary indictable offense. And again, the various other levels of sexual assault. Level 2 is a sexual assault that involves weapons, threats, actual physical harm, and here the penalty is maximum 14 years. And again, level 2 is an indictable offense. Okay, it's not a hybrid offense. It's prosecuted solely as an indictable offense. And then level 3 is the most serious form of sexual assault. It's called aggravated sexual assault. It involves particular physical harm to the victim, includes penetration and other very grievous aspects of sexual assault. And the maximum penalty for this level 3 is a life imprisonment. So again, level 3 is solely an indictable offense. So sexual assault, again, is an example of an offense that has various levels based on the seriousness of the offense. And it's also an example of a particular criminal offense that is a hybrid offense. In other words, can be prosecuted by the Crown as either a summary or indictable offense. Now I'd like to turn our attention now to the topic of amending the criminal code. And the important thing to keep in mind here, as we've discussed, is that the criminal code is a living, breathing, dynamic document. It's not static. It's something that's constantly changing, constantly being amended, whether through statute, law, or court decisions. And as such, it's constantly reflecting different priorities of the government, perhaps different priorities within society, and also it's reflecting the decisions of the court, and as importantly, how the court is interpreting laws created by the government through the Charter of Rights. So I'll give a couple examples of recent amendments to the criminal code. Some very well publicized amendments were made in the early part of this century, back in 2001 and earlier 1997, and these were basically amendments to the criminal code that revolved around organized crime. In 1997, the government introduced Bill C-95, and then in 2001, the government introduced Bill C-24. And basically, these amendments to the criminal code created a new offense, and that new offense was participating in a criminal organization. And it actually included a new legal definition. In this case, it defined what was meant by a criminal organization. This definition was necessary because obviously if you're going to charge someone with participating in a criminal organization, one needs to know what exactly a criminal organization is. So the new offense is significant because what it does is it creates enhanced penalties for a particular offense if an individual committed that offense in the context of his or her participation in a criminal organization. So for example, if somebody committed a drug trafficking offense, and the court or the Crown was able to prove that drug trafficking offense was committed to further the interests of a criminal organization, then that individual can get a even longer sentence than one that would be typically handed out to a drug trafficker who wasn't involved in a criminal organization. And so this is basically to penalize offenders who commit crimes for organized crime or for criminal organizations. The important context of this amendment to the legislation is not simply the substantive changes made to the criminal code, but as the context within which these changes were made. The context was actually the so-called biker war that took place in Quebec in the mid-1990s to late 1990s, and it was between the Hells Angels and their rivals, and they were fighting over basically who would control the cocaine market in that province. And there was particular bloodshed in this war. Over 150 people died. It became a huge public issue, not just in Quebec but throughout Canada. And so there was considerable pressure being brought forth on the federal government at the time to do something about this war. And again, one of the ways that the federal government had to respond was to amend the criminal code, again because they have powers, these exclusive powers to include to amend the criminal code. So one of the things they did was to amend the criminal code to basically include stiffer penalties for individuals involved in crimes that were committed for criminal organizations. So this particular amendment is a good example of how certain criminal offenses or certain criminal acts, in this case violent acts between rival criminal gangs, can lead to criminal offenses. So it's a good example of how particular current events in society can lead to pressure on the government to amend criminal code to respond to those offenses and to those criminal acts. In this case, it was a very bloody biker war that forced the federal government's hand, in this case, to create offenses that would hope to deter criminals from committing these offenses, but at least would increase the penalties for any offenses committed in the context of organized crime. But in summary, this is an example of where the criminal code was recently amended, and it was amended due to circumstances that were taking place in society. So the federal government felt certain pressure to act based on criminal conduct that was taking place within Canadian society at the time. Another recent amendment to the criminal code is one that we're focusing on this course, and that is Bill C-10, which is the Safe Streets and Communities Act, which was brought forth by the Conservative government. Some say this is a piece of legislation that reflects more the ideologies of the Conservative government than any reality that's taking place in society. So critics are arguing that there was no real impetus or need to introduce this legislation, this very punitive legislation, simply because the crime rate has actually been dropping in this country. The Conservative government will argue instead that there's still pockets of violent crime and that the penalties are too lenient, and that the best way to deter offenders is through tough laws like mandatory minimum sentences. I'm not going to go into great detail on this legislation. It was actually 9 pieces of legislation that were bundled together. So when the federal government got re-elected, they basically took this 9 pieces of legislation they introduced in earlier sessions in Parliament and bundled them together. But the important thing to, again, to consider here is, are the critics right? Is this piece of legislation an actual infringement on the principles of justice and reintegration? Is it moving the Canadian criminal justice system away from the model of justice reintegration towards punishment? And when one considers the legislation in that context, it basically shows how amendments to the criminal code by the federal government or by federal parliament can actually really change the nature of criminal law and the criminal justice system in Canada. So So this legislation is important for a number of reasons. A, because many critics believe it's moving the Canadian criminal justice system towards a more punitive or punishment-based system. B, it's an example, again, of how the federal government can amend the criminal code through legislation it introduces. C, it's an example of a very controversial approach that the federal government has into crime and law and order in this country. So I'm encouraging you through your readings, through the news forum, through debate and discussions with other students, through your research essay, to explore this piece of legislation in more detail and come to your own conclusions about whether or not it's moving the country in the wrong direction, whether it's going to have detrimental impact on offenders and on the criminal justice system, whether or not you believe these amendments are just and will survive, say, a charter challenge, and whether you agree with the court decisions that have struck down some of these provisions already. And the question there is, do the courts overstep their boundaries? It's elected officials that have brought in this legislation, whether the public likes it or not, and to what extent does an appointed judiciary have the right to radically change legislation brought in by an elected body, in this case the federal government. So very controversial in a number of aspects, and it's a good test of your critical and analytical thinking skills vis-a-vis examining this legislation and its impact on the Canadian criminal justice system, offenders, the criminal code, and Canadian society as a whole. So I want to talk very briefly about provincial forays into criminal legislation. So we've talked extensively about how the federal government has been endowed with exclusive powers to write criminal legislation. In other words, provincial governments are not empowered to write criminal laws. But that hasn't stopped some provincial governments from enacting legislation to address crimes. And they can't write criminal laws, but they can write civil laws that use civil penalties to address certain crimes or public behaviors. So one example is the Safe Streets Act, which was brought in Ontario under the Conservative government of Mike Harris, and this responded to a particular problem, and that was the squeegee kids. And these were kids that were cleaning the windshields of cars at intersections, often unsolicited. And many people were upset about this. They felt frightened by this or being extorted of money. And this was a topic that became quite an issue for the Harris government and their law and order agenda. So they brought in a piece of legislation that targeted this behavior. And they couldn't bring in criminal penalties because they don't have that power. So what they did instead was bring in fines and civil penalties. So the fines were from $500 to $5,000. And they also included provisions that allowed the provincial government to jail these offenders through administrative and provincial laws. So again, not under criminal laws, because they can't create criminal laws, but provinces can create certain laws that send people to jail. So for example, taxation laws or provincial security laws, for example. So that is one particular type of legislation that addresses public behavior through civil provincial legislation. Another area that the provincial governments are starting getting active in is trying to seize the proceeds of crime. In other words, the revenue from drug trafficking or other types of profit-oriented crimes. Now, the Criminal Code of Canada and the Controlled Substances Drug Act lays out provisions where the police and the courts can actually seize the proceeds of crime if that individual was convicted of a criminal offense, like drug trafficking. But the provinces wanted to get into this by using civil laws to seize those criminal assets. In other words, the provinces wouldn't seize the assets through the criminal courts. They would seize the assets through civil courts. And how they would do this is basically launching a civil suit. So they would sue the criminals for their assets. And it's very controversial because many argue that the provincial governments are going after criminal offenses through the civil courts, which shouldn't be done. The provinces like using civil powers with respect to criminal offenses because the burden of proof is lower on them. So in a criminal court, you have to prove beyond reasonable doubt that the revenue has come from a criminal source. In the civil courts, they only have to prove on a balance of probabilities, so that the proceeds came from that was basically illegally accumulated. So it's actually easier for the province to get to seize the proceeds of crimes through the civil court than through the criminal court because the burden of proof is much lower for the province in the civil court. But again, many people are very critical of these approaches because they say they're basically using civil approaches within criminal matters, and that criminal matters should only be pursued through the criminal courts. But here's just a couple examples again of how the provincial governments in Ontario have tried to address criminal behavior through civil laws, but these are generally exception to the rules. There's, most provinces leave criminal offenses to the criminal courts. Finally, I'd like to end this module by touching on one of the great controversies of criminal laws and criminal enforcement in general, and that is the extent to which criminal laws which prohibit certain vices or certain behaviors actually create more problems than they address. And the argument here is that criminal laws can in fact create even more crime and even worse crimes. And one example of that, of course, is the criminalization of liquor in the 1920s during the so-called era of Prohibition. In both Canada and the United States, governments there sought to and successfully outlawed the consumption and manufacture of liquor. That's considered one of the worst policy blunders in the 20th century. Why? Because these laws basically created organized crime. It simply misinterpreted or underestimated the amount of people who not only would continue to consume booze, but who would skirt these laws by providing booze to these people. So Prohibition basically brought in the modern era of organized crime. It also increased violence in society because these gangs were now fighting with each other to monopolize certain underground liquor markets. It led to massive corruption in the government because the bad guys were bribing custom officials and judges and police officers to look the other way. And it really created a widespread lawlessness in the United States in particular because most people didn't stop drinking. They continued to drink, and so a good majority of the population was actually ignoring the laws. And of course, this argument can be applied to the prohibition of drugs, the criminalization of drugs. The argument is that once you prohibit drugs, you create these huge underground illegal markets, you contribute to organized crime, you contribute to lawlessness because people are continuing to consume drugs, notwithstanding their illegality. So the question here, again, is to what extent can the state regulate and prohibit certain vices like drinking or drug use or prostitution or gambling. And the argument is that when the state steps in to start regulating certain vices, they basically create these huge underground markets which promote more criminal law breaking. So it promotes organized crime, it promotes drug trafficking, it promotes violence, it promotes corruption. And so the question is, are actually more harms created by prohibition and criminalization, and do these harms outweigh the actual criminal offenses themselves? And that's again one of these great controversies within criminal law and the criminal justice system. Should we treat, for example, drugs as a public health issue, where we try to treat users instead of treating them as criminals, where we outlaw the drugs and criminalize the traffickers and the consumers? And again, it's up to you to decide on whether or not the harm that's brought about by criminalizing certain substance actually exceeds the criminal offense itself. And this is a topic that you can definitely pursue in your research essay or in your case studies or in the discussion room. But it's one that again is significant to the study of criminal law. And again, the debate is whether or not criminal laws do more harm than good in some circumstances.